everybody. I'm Professor Paula Colby-Clements. I'm your last presenter of the evening, and I'm going to walk you through some ethical considerations when advising the corporate client. And when you think about this, I want you to think about it both as lots of law students here that might be advising corporate clients, but also if you're in a corporation and you're in the role of, say, an HR director, and you're creating policies to deal with corporate counsel, this sort of cuts both ways. So I want you to think about that as I'm running through some of this. So we talked about the Westons, and some of you might be sitting there. I know Dean Coyne's not one of these people that's feeling bad for the Westons because, the government really went after them. And you might be thinking to yourself, these are two educated people that had no criminal history. And I'm not saying they shouldn't have been punished, but why did the government go after them so vociferously? I thought I would point out, and by the way, I'm going to put a lot of information on the slides. I am not going to read it all to you. It's there for you to read later, but I want to point out a couple things. This is the Department of Justice Manual, and this section of the manual guides federal prosecutors on how to investigate and what to do about corporate crime. So one thing that I want you to notice is that it actually tells prosecutors that corporate directors and officers owe a fiduciary duty to a corporation's shareholders, those are the true owners of the corporation, and they owe duties of honest dealing to the investing public and consumers in connection with the corporation's regulatory filings and public statements. So with that as a backdrop, the manual goes on to tell prosecutors that their duty is to enforce the law, and that's going to require investigation and prosecution of criminal wrongdoing if they discover it. Another section of the manual says, hey, prosecutors, we want you to know, prosecution of corporate crime is a very high priority for the Department of Justice. Why? Because we have to protect the integrity of the economy and capital markets. We have to protect consumers, investors, and business entities. We need to prevent violations of the law, and we have to discourage unethical or criminal practice by corporations. So the manual goes on to tell them that one of the most effective ways to combat corporate misconduct is by holding accountable all individuals who engage in that wrongdoing. And because a corporation only acts through individuals, investigating the conduct of individuals is the most efficient and effective way to determine the facts and the extent of corporate misconduct. What you're seeing here is the embracing of the corporate entity idea. So now let's go over to our rules. When you represent a corporation, the first thing that you need to parse out and everybody has to be aware of is who is the client. So 1.13 under the Model Rules of Professional Conduct tells us that a lawyer employed by or retained by an organization represents the organization acting through its duly authorized constituents. So again, we're embracing that entity theory. The entity itself can have a lawyer. Now you say, well, wait a second, what? Does that make sense? How can the entity be the lawyer? How do you deal with them? Well, here's how you deal with them. You deal with the officers, directors, employees, and shareholders, because the rules say they can't act, the entity can't act unless it's acting through its officers and directors. And because of this, representing a corporate entity is actually one of the most conceptually complex areas of professional responsibility. Okay, so let's kind of start parsing this out a little bit. First and foremost, your job's going to be to protect the client, the organization. You represent the organization itself, not the constituents, right? Even though you're going to be dealing with the individual constituents, they're the ones that are going to be talking to you. You don't represent the person you're talking to, you represent the entity, right? And what the rules say is if a lawyer for an organization knows that an officer, employee, or other person associated with the organization is acting in a manner that is in violation of a legal obligation to the organization, we go back to that fiduciary duty, say they're violating that, say they're violating a law that might be imputed to the organization or is likely to result in substantial injury to the organization, then you shall proceed as is reasonably necessary in the best interest of the organization. So that's pretty clear. You're dealing with somebody who's an individual for the corporation, but you don't represent them. So now you got to do what's reasonably necessary. What does all of that mean? Well, when one of the constituents of an organizational client communicates with the organizational's lawyer in their professional capacity or their organizational capacity, that communication is going to be protected by confidentiality. And it's going to be protected by attorney-client privilege. But it's only the entity that can waive confidentiality. It's only the entity that can waive privilege, right? So we have a few things to parse out when we start to think about somebody's communicating to us, but we don't represent them, we represent the organization. We're worried about harm to the organization. When do we report? How do we report? Who do we report to? Okay, a few things first. First of all, if you're representing them and the constituents are making decisions, generally, we have to accept those decisions, even if their utility or prudence is doubtful. So decisions concerning policy, operation, even things that entail high risk. Hey, I'm gonna go invest in this, and the corporation might make a lot of money, or it might be a bust and we might lose all the money. Usually those are not within the lawyer's province. However, when the lawyer knows that the organization is likely to be substantially injured by action of an officer or other constituent that violates a legal obligation, or again is a violation of a law that's going to be imputed to the organization, that's when we now have to act to protect the organization. So now you say, okay, I think I get the problem, but I can't tell because the communication is confidential, but I have a duty to tell because I have to protect the organization. What do I do? Okay, no, you can't punt, right? So you have to consider a few other things. All right, so what do you want to think about? Give due consideration to the following. First, think about the seriousness of the violation and its consequences. The responsibility of the organization and motivation of the person involved. Was it intentional? Did they commit a fraud? Did they make a mistake? The policy of the organization concerning the matters, and any other relevant considerations. What does all of that mean, Professor? Generally speaking, you're going to have a duty to report it to a higher authority. No, not quite that high. What that actually means is you're going to report it to the highest authority within the organization to whom you can report. Okay. So now you're also saying, well, you started with that justice manual. Now I have a duty to report up. I kind of get that. Do I have a duty to report out to protect the public? Well, let's talk about 1.6, the duty of confidentiality. What you have to know is that a lawyer shall not reveal information relating to the representation of the client unless the client gives informed consent. Can be impliedly authorized. That's not really as relevant here. What I want you to understand is that the communication, anything those constituents tell you through the representation is going to be confidential, and you can't report it out unless the organization waives it, right? Two exceptions here that I want you to be aware of, and they generally deal with when the lawyer may reveal. Without the authority of anybody within the organization, there's times that the lawyer gets to act. So I put those two exceptions up here. And remember, it's not a shall, it's a may. They never have to. But if you find out that you can report information that's going to prevent the client from committing a crime or fraud that's reasonably certain to result in substantial injury to the financial interests or property of another, and in furtherance of which the client has used the lawyer's services, or again to prevent, mitigate, or rectify substantial injury to the financial interests, property of another, reasonably certain to result or has resulted from the client's commission of a crime, and again, of which the client has used the lawyer's services, you can report out, right? But I underline that last part because we always sort of immediately think, oh God, they've done this. Let's report it out. Shareholders are going to be hurt by this. If you're not using the lawyer's services to commit those crimes or commit that fraud, you can't invoke the may and report out. It shall stay confidential. Okay, let me give you an example of this. There was a corporation, and this is from a New Jersey ethics opinion that interpreted the model rules, and the lawyer was retained on an hourly basis, outside counsel, to work with the corporation. They've been working for the corporation for a couple of years, and the only high-level manager that the lawyer ever dealt with was a credit manager. Life goes on okay, but then one day the credit manager gets hurt at work and doesn't like how the corporation is treating him. He thinks they're violating workers' comp laws, and he starts to get upset, and he says to the lawyer, I want to bring a claim, and he starts asking for legal advice. And this lawyer knew his role, and he said, hold on. I'm not your lawyer. I know that I've only dealt with you, but I represent the organization. If you've got questions about bringing claims against the organization, you need to go get outside counsel. But the manager didn't go quietly into the night and just get outside counsel. He started to tell the lawyer other things. Hey, I know a lot of bad things this corporation's doing. They're engaged in criminal activity. They're engaged in fraud. And if I disclose this and it goes public, the corporation's going to get hurt really bad. So now the lawyer said, I'm not really sure what to do here. Do I have an obligation to tell the corporation I have this dealing with the constituent? Do I have to discontinue representation? Do I have to divulge the information to somebody outside, to the appropriate authorities? And here's what the ethics opinion said in guiding the attorney. First, certainly, as you would think, that duty to report up, since the allegations involve violations of the law, which if they were proven, they were likely to result in substantial injury to the corporation, then the lawyer had a duty under the rules to report up, to take that conversation, report it to directors, officers, presidents, let them do the investigation. In terms of a duty to withdraw at that point, what they said was all of the allegations in this scenario were about prior acts of the corporation. So there was absolutely no danger that the lawyer was counseling or assisting the corporate client in conduct that the lawyer knew was criminal or illegal, so they could stay on as counsel. But here's the real interesting one. If the investigation disclosed that the allegations had substance and they did nothing, or if the president and the directors decided not to investigate at all, either of those scenarios, corporate counsel had to keep the information confidential. They had no right to disclose privileged information and no right to reveal confidential information to outside authorities unless they were given consent by an officer, director, or president of the company. Okay, so it's important to understand your role. And this is one of the big takeaways I hope that students that do represent corporate counsel think about, and also if you are a director or an officer of a company, to think about your policies. You're going to have a duty to warn. That means when you're speaking to those constituents that you talk to, high-level employees, you're doing an investigation in the plant because there's something wrong on the manufacturing floor and you try to figure out what's going on, you might be prohibited from sharing information that you need to report up if you don't warn that person. If that person comes to you and they reasonably appeared to be consulting with you as a present or prospective client with respect to their individual interests, and you failed to warn them that you only represent the organization and that you could use that information against them, the rules say that that information suddenly becomes confidential between you and them. So let's say you forgot your role or you just forgot to tell the client. Let's say it's Chris Weston. He comes to you, your corporate counsel, and he starts to say, hey, I got a call from the feds. I think I'm in trouble. And instead of saying, Chris, hold on, you just say, Chris, what's going on? What happened? And he starts to tell you, I've been padding bills. I've been sending them, right? You've now created a problem. You've created what we call a concurrent client conflict, okay? Two rules are going to come into play here. First, if you cannot represent two clients at the same time, if the representation of one client is going to be directly adverse to another client, or if there's significant risk that the representation of one or more clients is going to materially limit the lawyer's responsibility to the other client. So you could say I've got a real problem here, right? If Chris is telling me that he's now engaged in criminal activity that's hurting the corporation, I didn't warn him, I now can't report it up. I certainly can't represent them both, right? Because if I tell the corporation, Chris is going to get in trouble, right? So I got a real problem here. And you're saying, how did I create this problem? I knew my role, but in the moment you forgot. You dealt with him all the time, and you said, go ahead, tell me what's going on. Because the thing is, you know your role, they don't. They forget. They deal with you all the time. They think you're their lawyer, and you're not, right? So now we also have to think about Rule 1.18. This is just background to understand why it's a concurrent client conflict. And essentially what these rules say is that anybody that comes to you and is seeking legal advice for themselves, they're going to become at least a prospective client, because you're probably saying, well, he's not a current client. At some point, I hope you shut the conversation with Chris down. But the rules say that when they come to you for that legal advice, that confidential information can no longer be revealed. So you can create conflicts by allowing the client to start telling you a lot of information that now you have confidential and can't use to adhere to your duty to the corporate client. Okay, so now what do? You have information from Chris. You think you have to report it up. You're between a rock and a hard place, right? You know you can't reveal the information to the corporation you owe duty to. You have a duty to protect the organization and report up. You can't hurt Chris now because you have confidential information can hurt him. You have a non-waivable conflict, right? If it hasn't become public, it will when the feds start pursuing Chris. But now you can't tell the corporation it's coming because the rules of confidentiality won't let you. Do you wait until it becomes public, tell the corporation to get another lawyer? In the meantime, you're sitting there knowing the train's coming down the track and the corporation's going to get creamed, right? If it's already public, same problem. So what are you doing? Chris, I can't represent you. Corporation, now I can't represent you. You've created a really big problem by not having good, strong policies. Let me tell you another real-world situation. Big company conducts an investigation into an accident at its factory. Employee Johnson speaks to the investigators and tells them big company wasn't at fault. So Johnson's just an employee. He's going to be a witness in this investigation. So big company says, hey, our interests are aligned. It's okay. Corporate counsel, you can represent me. Go ahead and represent Johnson at the deposition. Counsel says, okay, during deposition preparation, I represent Johnson. I represent the corporation. Now Johnson says, guess what? I lied to the investigator. Big company's definitely at fault. Now counsel has a problem. What does he do? He's created a conflict, right? In the real case, what he tells Johnson is, well, you're going to have to go ahead and sit for the deposition, and you're going to have to testify truthfully, right? You have a non-waivable conflict here. Why is the conflict not non-waivable? If the employee testifies truthfully like you told him to against the company, counsel has to cross-examine his own client, Johnson, in order to make the company look better, right? Try to undermine his credibility at the deposition, right? Worse, if the employee goes in and now testifies falsely at a deposition, you've got a duty of candor and you have to fix that falsity, right? So you've got a problem either way here. And in the real case, what happened was the company testified truthfully, then Johnson was obviously fired, and then the attorney was sued for malpractice and paid out a big fee. So, final thoughts. When you are corporate counsel, or if you hire corporate counsel, you really want to think of the role of the attorney. We have duties that we owe clients, but we also engage in the role as an advisor, right? And we can render advice that refers to the law, but we can also render advice and take into consideration things like moral, economic, social, and political factors. And we should be thinking about all this practical advice when we advise our clients. Some things that you want to do in terms of best practices when you represent a corporate client. One, maintain clarity in the attorney-client relationship. Make sure the employees know who the client is. When you deal with the organization's constituents, explain the identity of the lawyer-client. If you're investigating something that's happening and you're talking to witnesses, let them know I represent the corporation. What you're telling me is not confidential, it's not privileged. Communicate frequently the scope and limitations of your relationship, and implement documentation policies and communication rules and procedures so that people know how to deal with general counsel for the corporation. And that's whether they're in-house or outside. So hopefully some of that gets you to think about representing corporate clients. It's helpful to know whether you're going to be the attorney or whether you're an officer or somebody within the corporation hiring counsel and letting other people interact with counsel. So thank you very much for your time tonight.
Thank you all for coming today. I really appreciate your attention and appreciate your time, and especially thanks to all of those who participated and planned this event for us as well. Thank you all very much.